Welcome to Chapter 17. We will be discussing employee relations, and that is not about you dating a coworker. So let me clear that up now. So let's go ahead and jump into Chapter 17. Make sure you take good notes because this will be on a quiz and exam. By the time you're done reading this chapter, you should be able to explain employment at will, arbitration programs, causes of disciplinary actions, progressive discipline, grievance procedures, just cause, due process, the duty of fair representation, and grievance arbitration. When we talk about at will, it's easy to discuss this in the state of Georgia because it's an at will state. Basically, it means that you can quit your job or your job can quit you at any time for any reason at all or no reason at all. You just up and quit, or they can just up and fire you. There are arbitration programs that non-unionized organizations have created, and they're used for dispute resolutions. And you're required to sign an agreement as a condition of your employment. And there are some issues that HR and senior management must always take in consideration. And those two are whether or who's going to administer the program, and will this program be imposed only on new hires, or will current employees also be brought in under this new program? Now, we look at our disciplinary action, and there's two main causes for bringing discipline against a employee. And if they violate a rule of the organization, or if they fail to perform at a significant level where action is deemed needed. There are, and I'm going to expand this, some reasons for discipline and for discharge, which is termination, which is firing. Of course, you can see the obvious ones. If you're absent all the time, late all the time, if you're stealing from the company, if you're abusive to customers, if you're dishonest, if you lie about something on your employment application, if you're in possession of any kind of drugs or intoxicants, if you're a gambler, sleeping on the job, negligence, sexual harassment, racial slurs, refusal to work overtime, refusal to accept your job assignment, profane or abusive language, and if that abusive language is directed towards a supervisor. So you can see all of the different ways in which that you can be disciplined or fired from your job. And this was taken from the Bureau of National Affairs guide from how arbitration works. It's the 4th edition in 1985. And really this list has not been modified across the board at all. I'm sure that eventually this will actually probably also include bullying, and I can also see it expanding to beyond racial slurs to also include religion as well, with the current climate of our country and the world. Now, here's some steps that need to be taken in order to administer this process. You have to be able to establish what the performance requirements are and what the work rules are. Those work rules need to be relevant to the successful performance of the job. It cannot be something that you just pull out of the sky. It has to relate to the job and how an employee performs their job. Then it has to be communicated through orientation, performance appraisal, and any kind of ways that you can be able to interweave it within your organization. And then making sure that when it's necessary, you take corrective action. So when an employee fails to perform as expected or they violate the work rules, you need to be able to take immediate corrective action. And we'll go further into that in a moment. So here's some recommendations for before you're disciplining. This is what you need to be able to have in place as a manager. You need to be able to collect all adequate records and making sure that they are written and that they have a significant influence, so they won't be overturned or upheld in a disciplinary action, and that any past infractions or low performance are also recorded. Then in an investigation, your accusations must be supported by facts. Their employees' work records should be considered, so they're looking over the entire length of the employee's employment versus one isolated incident. And the employee must be given an opportunity to present their side. It cannot be a one-sided case against them. Now, here's some reasons why your disciplinary action can be overturned. You did not provide proper and sufficient investigation. You rushed to judgment, and you took action way too soon, and you did it when you were angry. Or you did it when you're angry, right? So one, two, or all three of these things could take place, and your action would be overturned. In 1975, the Supreme Court gave Weingarten the right to, and other employees, the right to refuse to be part of a disciplinary interview if they did not have union representation. Union representation, I got a little tongue-tied there, allows you to have a person be your eyes and ears to see where a conversation, an interview could be leading, and if there's any violations of your rights based on any state or federal guidelines, as well as any union contracts that have been formed between the union and the employer. And make sure that you guys really read about that, because it's very beneficial. A lot of people that work in unionized organizations don't realize the importance of making sure that they have a representative and that they have the right to ask for one. So here's some guidelines for administering discipline. You need to make sure it's done immediately, right? Someone did something, and you need to act on it right then and there. Now, if they did it on Wednesday and they don't come back to work till Friday, and they did it at, the close of business on Wednesday, and you couldn't jump on it then, as soon as Friday comes, you need to. Don't wait till next Wednesday. That's not immediate. That's delayed. And the same is true, like when you think about in your personal life, your child breaks your dining room table, you're not going to wait a week to discipline them. Now, there has to be advance warning. An employee needs to know that there's an infraction, and there's a warning. If there's not a warning, if you've been watching me come late to work for a month straight and you say nothing to me, and then you discipline me, but you never warned me. You never said, hey, don't, you cannot come, you know that you're not supposed to come to work late. You know that's one of our rules. Don't do it again. If you don't warn me, bring it to my attention, then you possibly risk disciplining me. You possibly risk that action being overturned. Consistency. Just like with your children, your other family members, the same is true in your employee-employer work relationship. As an employee, I should believe that other employees are going to receive the same penalty for doing the same or similar offense. So if I look around and I'm the only one being punished, I'm going to take it personally. And so will the court of law. So one thing that's important is that as a manager, you need to always make sure that personality differences are not a factor in your application of discipline. Just because someone rubs you the wrong way, just because you don't like their personality, does not mean, it does not support your mission to discipline them. You know, you come down, like the hand of Zeus on them, but you wouldn't come with that same level of intensity with someone else who committed the same offense. Then that's a personality issue. And at that point, shame on you. So you need to make sure that that is not a reason. It has to be because a rule is broken or the performance has consistently just not been up to par. Now, when we look at how we do our corrective or progressive discipline, there's some sequences that must be taken. First, of course, there has to be an oral warning. I have to tell you verbally, hey, you did this or did that. Then I need to put it in writing. Right? So it's I warned you, you did it again, it's in writing. Now the written may actually come right after the oral. I may say it to you verbally and then also put it in writing as a reminder. So it's in writing. Then when you do it again, right, what am I going to do? I'm going to do orally and again in writing. And we're just going to keep going back and forth. Oral, written, oral, written. And as we're doing this oral and written, that paperwork is going to pile up. I'm going to have that paper trail piled up. Because that's the only way that's going to lead to suspension and discharge. Now, let me say this. It sounds very vindictive. I'm not saying, yeah, you guys sit back and start stockpiling these written warnings. No. I'm saying that if you have a person in every organization, just like every family, we've got a wild child on our hands, right? We have, there's different analogies. You have a rotten fruit. You have a person who's just not a good fit. You have a person who is intent on causing negative disruption, right? Not even a positive disruption in your unit. And you can't just go from oral warning to discharge or oral warning to suspension because it's your word against theirs. And how does anyone know that you actually even told them, that you actually warned them? So you have to put it in writing. This is what happened. You've been warned. You were warned repeatedly. Here's all the other previous warnings. At that point, you can suspend and then discharge, or in some cases, you can just go straight to discharge, depending on the severity of the offense. Now, here's some legal restrictions. You cannot use race, color, religion, sex, or national origin as a reason to employ a person or not employ them. And that is based on the Civil Rights Act of 1964. You also cannot discriminate against a person who's over the age of 40. We have a lot of age discrimination going on through the country. We have a lot of states who are faced with a aging population who is still working, as well as an aging population who is returning to work, and they're being discriminated against. And The Age Discrimination in Employment Act is supposed to protect those individuals. The interesting thing is that a lot of people don't even realize they're being discriminated against. So in interviews, one way that people are being discriminated against is certain questions that are being asked that help the interviewer determine your age. So if they ask you a question about President Ronald Reagan and you speak with great passion for or against him, recalling his presidency, then they know that you are over the age of 40. And most likely over the age of 60. At that point, if they want an organization that is mostly filled with 20-year-olds, then they're going to discriminate against you. They're going to find a reason to not hire you. So things like that take place. Asking you a question such as, what did your parents think about the Great Depression? Well, at that point, we now know that you have to be in your 60s or older in order for your parents to be able to tell you anything about the Great Depression. So it's little tricks like that, and it's not, of course, not that particular question wouldn't be relevant, but it has been used before based in an organization that was dealing with financial instruments and things of that sort. So it's a way in which you can subtly and slyly ask a leading question just to be able to determine an age and to discriminate. So those are the ways in which it's used. Of course, the most obvious is race, color, sex. National origin and religion are not as easy because so many people assume that they know someone else's religion and they're like wrong. They think someone's Muslim and they're actually a Sikh. They think someone's Muslim and they're actually Jewish. It's like people kind of really just have no clue. Someone thinks that someone's from the Middle East and they're actually from like Western Europe or something. It's just really, so those are not as obvious, and usually color plays into that more so because they can't really gauge where that person's, their national roots are from or what religion they are. But if those information is ever disclosed, then of course that can also be grounds for discrimination. So we have Alexander versus Gardner Denver, and it was a decision in 1974 by the Supreme Court that uses a final and binding grievance in an organization does not preclude you as an aggrieved employee from seeking any kind of redress through the court action. All right? It is not going to stop that from happening. So I want you guys to read more about this court decision. It's in your textbook. And if you want to go even deeper, search online and explore. And I will actually include a note for myself to be able to share any possible links with you to help you with your exploration of this. But simply Googling it, and I hate to give Google the perks for that one, but simply Googling that will pull up this court case and allow you to explore this even farther. So let's look at our grievance procedures. Now, it's the outline of steps that employees have in order to appeal any action that management took against them that they feel violates their union contract. and that was created in negotiations with the organization. And in a unionized organization, when you feel that the action taken by your manager, the company, was inconsistent with the contract, you then can contact your union steward to discuss what happened, and then the two of you meet with your supervisor, and that grievance is put into writing, and then if you can't seem to come up with a mutually agreed settlement. Now, in just cause actions, the manager and the company has to bear the burden of proof of wrongdoing. They have to prove beyond a reasonable doubt, right, that the reason for the discipline was justified and that the severity of that punishment was tied to the seriousness of the offense done by the employee. And there's some guidelines that should be considered, like your past performance as an employee, if there were any previous disciplinary actions taken against you, if there were any unusual circumstances surrounding the alleged offense. And then when we look at due process, were you dealt with fairly and justly during the investigation, the administration of the subsequent disciplinary action? And if not, then breach can result in a modification of the disciplinary action or complete reversal. In order to ensure due process, the contract terms must be followed. There must be adequate warning prior to the discipline. There has to be an explicit statement about the possible disciplinary action that can be brought against you, and you have to be able to have a full and fair investigation that's conducted immediately after the offense. It cannot be weeks and months and years later. There must be an immediate investigation, and it must be very thorough and fair. Now, fair representation. Under our National Labor Laws Relations Act of 1935, the union has a statutory duty to fairly represent all employees in the bargaining union, whether or not they are union members. So you don't even have to be a union member to have representation. This is why some people, and I'm not sure why, but some people are trying to do away with unions. You've noticed our unions have actually dwindled in size. They are being forced out by huge power structures that are forcing them out. You also have where a lot of employers are standing firm in their conviction that they will not allow for a union to be in their organization. And I remember working for an organization back in the early 2000s, and the CEO said in my orientation that if he ever found out that anyone was trying to create a union or bring a union in, that they would be immediately terminated. I told him, in my own way, that was actually a violation of our rights, but whatever. But they really have a very vital and valuable role because they speak for you. They're standing up to the bigger person, right? It's like when you're being picked on by the big giant. Well, they're another giant, and those two giants that can battle it out for you, and they're protecting your job in the meanwhile. Or if you've been terminated and you have a grievance against that, they're helping to fight for you in order to either A, bring you back into your position, or B, create a settlement agreement that compensates you for that severance in your employment. Now, we have Vaca versus Sipes, and that's a court decision that the Supreme Court held that the union is not obligated to take all grievances to arbitration. They have authority to decide whether or not it has merit, and they haven't breach their duty of fair representation if a decision is made fairly and non-arbitrarily. In Bowen v. the U.S. Postal Service, 1983, the Supreme Court established that an employee is entitled to recover damages from the union and the employer if the employer violated the labor agreement and the union has breached its duty of fair representation. And remember what we said, you need to look under the National Labor Relations Act of 1935 to really go deep in that. Now, here's some criticism of this procedure. It takes a lot of time, right? And the employer has the advantage because they have more money, and you are holding the short end of the stick because your money comes from that employer. So it can take a long time, and it could take up to several months for an appeal to take place, and several months to a year or even longer before a final decision is even reached. So it could take years for your grievance to be decided on. Some people just give up, not even halfway. Some people give up soon into the start of the process because it can be very grueling. Now, there's grievance arbitration, and you see that I have the Federal Mediation and Conciliation Service, FMCS. And this is where you attempt to settle any unresolved disputes during the term of your collective bargaining agreement that involve any questions of interpretation of that agreement or application and how that agreement is applied to you and in the workplace. And provision is not mandated by law. There it's the final step in the grievance process. And I already mentioned FMCS. There's also American Arbitration Association, which most of you have probably seen that on some of your employment documents, as well as you'll see it in other things. AA is also, you'll see it on rental applications, paperwork, that if there's ever a dispute, you'll go through the association. Now, Enterprise Wheel. This is a Supreme Court ruling in 1960 that as long as an arbitrator's decision involves the interpretation of a contract, the court will not overrule the arbitrator because their interpretation of the contract was different from that of the arbitrator. So it won't be overruled because of interpretation. Now, that is it in a nutshell. Of course, this chapter is more extensive, has more depth, but as you can see, this had nothing to do specifically with you dating a coworker. When we talk about employee relations, it is helping with the energy and synergy of your human resources that you have, and as a human resource yourself, in making sure that you're protected. And it also will make sure to protect the organization from any kind of grievance, potentially any lawsuits against them for failing to follow the process and actually even having a process in play. So with that, if you have any questions, please feel free to email me. Have a wonderful day.